Welcome, everyone. My name is Ryan Susky, and I'm Director of Programs at the Ohio Center for Law-Related Education. And we are here for the Unit 4 hearing from Faith Lutheran Middle School for the We the People National Invitational. In just a moment, I'm going to go ahead and have the judges introduce themselves, followed by the students, and then we will begin the hearing. The hearing today will take the form of a 4-minute prepared statement, followed by 8 minutes of judge follow-up questions. Now, my microphone will be muted during the hearing, but I will be holding up the time cards for the students to see. And for that reason, we do recommend that you use gallery view rather than speaker view so that you can see my time cards and, of course, your colleagues. At the conclusion of the hearing, the judges will give brief feedback to the teams, and then we will be on our way. At this time, I'll go ahead and hand things over to your chairperson to begin the introductions.
Hi, Faith Lutheran. It's nice to see you again today. I'm Diana Owen, political science professor at Georgetown University.
Hello, I'm Deshawn Whitaker, We the People teacher in Charles County Public Schools in Maryland.
And I'm Joe Stewart, teaching political science at Clemson University in South Carolina.
And if you could all introduce yourself and your teacher, that would be great.
Hi, my name is Nicole Cook.
Hi, I'm Maddie Murray.
Hello, my name is Amanda DeVries.
I'm Wyatt Carroll.
And we are here at Faith Lutheran Middle School and High School with our teacher, Mrs. Carroll, and we will be presenting Unit 4. And thank you for your time.
Great, thank you. So as you can guess, today's question is number 2. So if the law has been properly passed by the lawmaking branches of a democratic government, why should judges have the power to declare it unconstitutional? Do you agree or disagree with Robert Dahl? Why? What is judicial review and why is it controversial? What has been the impact of judicial review on American society? Once the Supreme Court has decided that a law is unconstitutional, what power, if any, do people have to change the Constitution? Please begin.
John Marshall claimed it is emphatically the providence and duty of the Judicial Department to say what the law is. Those who apply the rule to cases must necessarily expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each. As seen in Marbury versus Madison, the Supreme Court held the power to utilize what laws they deemed important to the case. With judicial review, the court can take what they believe a law means and use it in their ruling.
William Marbury took his case straight to the Supreme Court, stating that the Judiciary Act of 1789 gave him that right. John Marshall interpreted that rule, affirming that the part of the Judiciary Act that granted Marbury the right to bring his case directly to the Supreme Court unconstitutional. This was because the Constitution limits what cases are allowed to go straight to the Supreme Court. This case did not fit within these constraints.
Marbury should have tried his case in a lower court first, and then, if necessary, eventually tried in the Supreme Court. When that section of the Judicial Act passed, Congress changed the Constitution. Congress does not have the right to do this on its own. In doing so, more power was given to the Supreme Court. However, that power was unconstitutional. Through judicial review, the Supreme Court declared the law passed by Congress null and void.
Chief Justice Marshall stated, Congress did not have the power to modify the Constitution through legislation because of the Supremacy Clause. The topic of judicial review is controversial because many people debate whether the judicial branch should have the power to rule a law unconstitutional. They argued that the power might influence judges to sway towards their own political beliefs and opinions, affecting their judgment in court cases.
Another reason why judicial review is controversial is because it interferes with administrative law. Administrative law is the law that regulates the operation and procedures of government agencies. Under Article 3 of the Constitution sets forth the purpose and duties of the court system. Only those cases that involve a constitutional issue are addressed by the Supreme Court. Marbury versus Madison did not quote unquote create the court system. Marbury versus Madison simply expanded court jurisdiction to include the authority on rule of matters that were not specifically addressed in the Constitution.
Article 3, Section 1 states, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The Supreme Court holds the power to pertain what laws they deem important to a case with the power of judicial review. It remains a vital part of the judicial system as it gives courts the power to interpret the Constitution, allowing them to give accurate and fair verdicts.
In Roe v. Wade, Jane Doe, a fictional name given to protect the defendant's identity, filed a lawsuit against Harry Wade, who was the Dallas County, Texas District Attorney. She challenged a Texas law that made abortions illegal with the exception of a doctor's order to save a woman's life. In Roe's lawsuit, she stated that the state laws were unconstitutionally vague and abridged her right of personal privacy protected by the First, Fourth, Fifth, Ninth, and 14th Amendments.
The court used judicial review in the ruling by applying the right to privacy established in Grizzle versus Connecticut. Justice Rehnquist believed that the majority had misconstrued privacy and debated that the court's sweeping invalidation of any restrictions on abortion during the first trimester are impossible to justify under the standard.
As new discoveries are made, new truths are discovered, and manners and opinions change with the change of circumstances, institutions must also advance to keep the pace with the times. After the Supreme Court rules a law unconstitutional, the people do have the ability to change the Constitution, but it is very difficult. Article 5 of the Constitution outlines the basic procedures for proposing a constitutional amendment.
Congress may submit a proposed constitutional amendment to the states if a proposed amendment is first approved by a 2/3 vote of both houses. Congress must then call for a constitutional convention for proposing amendments upon application of legislatures of 2/3 of states. Amendments proposed become valid only when they are ratified by the legislatures or conventions in 3/4 of the states.
In conclusion, not a single amendment has been passed since 1992. Only 27 amendments remain today. This raises a question: is the process of amending the Constitution too difficult? Individuals think that the Founding Fathers made the process of amending the Constitution difficult on purpose. If the process was too easy, the opportunity exists for a multitude of amendments, potentially contradicting each other. We are now ready for questions, and thank you for your time.
Thanks very much. I was wondering if you could go into the concept of judicial review a little bit more deeply and talk about what judicial review actually is and how it was justified by Chief Justice John Marshall.
Judicial review is the power that the Supreme Court has to, any courts have, to interpret what they think the Constitution means, because our Constitution is really vague, and therefore the Supreme Court has the power to interpret what they believe the Constitution means and use it in the ruling. For example, in Heibel versus Judicial Court, District of Nevada, Humboldt County, the court used the power of judicial review to interpret what the Fourth and Fifth Amendment mean, to apply it to the ruling, and how the verdict would mean what the verdict is. And by using this I feel like judicial review is really important to the Supreme Court and any courts, because it gives them the power to give fair and just verdicts. And without judicial review, they can't really interpret the Constitution. And without that power, they can't give a fair or just verdict.
Okay. Do you think that judicial review is essential to protecting the rights of minorities against the will of the majority?
I believe that judicial review is very important in protecting the right of protecting minorities' rights, because without judicial review, because if you're in a court case and the court doesn't have the right to judicial review, they can't correctly protect you and correctly go about trying the case, because without it, they can't interpret what the Constitution means and apply it in the ruling.
I completely agree with my colleague, because if we didn't have judicial review, many cases their verdicts wouldn't be, I don't believe would be completely constitutionally correct. And with judicial review, they can relook over the cases and make sure the verdict's right.
I want to try to figure out exactly what we want judges to be doing. You talked about, and I got the sense that you were somewhat worried about judges using their political views to make decisions, but you've also argued that we have to have judicial review to reach fair and just decisions. How do we balance that? Am I correct in saying you're worried about judges using their political views? And I guess if so, why is that a problem if what they're going to do is reach a fair and just decision?
I believe that the judges may use their political views to reach a verdict in a case that's not fair, because if the case was pertaining to something that is going against their political party, they may choose not to use their power of judicial review to make the case swing towards their political party or the exact opposite and use judicial review to make the case swing towards their party. But we also need it because it allows judges on a case-by-case basis to look over the Constitution and what is in the Constitution and make sure that it is constitutional and applies to the case fairly and justly.
I agree with my colleague because in today's society, we're really set with our views, and it is hard to remain unbiased in any it's really hard for anyone to remain unbiased in different situations, especially when you have that amount of power. It becomes hard to restrain yourself from remaining unbiased. So I definitely think that it is hard for anyone to remain unbiased. So I do agree with my colleague that it is hard it's our right to be worried about whether or not our judges will go about using the power correctly.
Okay. Do you think that the Supreme Court justices should be elected by the people, or do you think the system where they're appointed by the president and confirmed by the Senate is working?
I personally think that they should be elected by the people, because if we have a Democratic president, they will also elect all the House and Senate. They would all be Democratic also. So I feel like we need to even out the power between different political parties.
I agree and disagree with my colleague, because I do believe that we should, because us, the people, we have the most power, but I believe that it's also the president's job to elect, and appoint who he believes is deemed necessary, deemed fit for the job. And I do agree that if we have, for example, Joe Biden, he's trying to appoint Democratic judges to the Supreme Court, packing the court. A lot of Republicans are scared that the court will become completely Democratic, but there's also a bunch of Republicans who are trying to appoint Republican judges to the Supreme Court. And I think with this, then there's an even balance, because it could be too many judges. And I do believe that the people should have the right and have a say in who is appointed to the Supreme Court.
All right, so let's stay on that idea of electing the justices to the Supreme Court. How do you feel about them serving for life?
I personally feel that them serving for life might not be the best idea, because when we elect them and then they serve for life, we're stuck with those judges. And if they prove themselves to be unfair or unbiased, we have to then remove them from the courts instead of their terms just ending. So I feel that if we implemented terms, it would make it so there weren't as many, if there were unbiased judges, biased judges, that they would leave the courts and they wouldn't stay there forever and keep making verdicts that weren't fair and just.
I agree with my colleague, because the courts are supposed to remain to neither political party. They are supposed to review the Constitution. And if there is some judge out there that will sway towards their own political beliefs, we have to get rid of them to maintain the balance of the country.
I agree with both of my colleagues, and I do believe that, and because of this, I believe that judges shouldn't be in courts for life, because after a while they could also be unfit for their job, because maybe they could suffer from an illness which makes them unfit for the job. And as times change, the different ideas develop and change with times. And if, let's say, there's a judge that has been in the court for a very long time, they're probably set in their ways, and we need to be able to have different ideas and viewpoints as time progresses.
Okay, so would you agree then, when President Roosevelt proposed what we call the court packing plan, he was going to ask for the authority to appoint or nominate a new justice for every justice over 70 years of age? Did that seem like a good idea to you?
I believe that is, because after a certain age, you're not, you're become to a point where, you still have the right to think, fully believe and think. But after a while, it becomes harder to maintain your job, and you definitely do develop certain illnesses. You just become weary, and I think it's best to have, fresh and new different ideas. It is good to have older people because they definitely are more knowledgeable, but I definitely do believe we should have that variancy, or that different ideas.
Thank you.
Thanks very much for your presentation and the discussion. I really enjoyed it. I thought that you did a really nice job of talking about how judicial review came about, starting off with John Marshall and Marbury versus Madison. And I thought you did a nice job of talking about some of the problems with judicial review, and something I thought was interesting throughout both your presentation and your responses to the question was the idea that you know, things change with the time. The institution has to keep pace with society, and the judges themselves also need to keep pace with society. And so I think by talking about maybe there should be limits and maybe, you know, kind of bring younger voices onto the court, that same idea kind of gets carried through. I also, you know, thought you did a good job of talking about the amendment process, and you know, you described it, but then you talked about how it's really difficult. So if, you know, people are listing this as a way that the people can get into, you know, kind of interpreting the Constitution and changing the Constitution, that it really hasn't happened that often in our history, and that it's a very difficult process. In response to the question about you know, the judges and whether they should be elected by the people that I asked, I like the fact that you brought in the contemporary example of what's happening right now, about how, you know, there's some suggestion that President Biden might, you know, kind of add justices to the court because it leans too conservative, in a sense trying to pack the court. And so he now has a commission that's studying that, and bringing that contemporary issue in, I thought was really well done. So I really enjoyed your presentation and the discussion. Good job.
Yes, I agree with my colleague. I enjoyed speaking with you today. You told the story of Marbury versus Madison and how we established this principle of judicial review. I like how you brought in your contemporary examples of judicial review and how they fit into our conversation, and how the amendment process is a bit difficult. And I would have liked to talk some more about proposals to how to make that better, or maybe what were some alternative thoughts you had. I also wanted to spend a little bit more time talking about how you think we should elect judges, because someone mentioned that the people should have a say in it. And I'd like to know how you think that should go about, but maybe for another time, we'll talk about that. But overall, great job, and thank you again.
Yeah, I agree,
Thank you.
colleagues, and I think you've demonstrated you're well equipped to wrestle with these difficult issues, that you realize we don't want judges being biased per se, but how do they reach these fair and just decisions? And it's hard to structure it in an appropriate way. You talked about the split decisions that we get in the courts. One of the things I will suggest to you, keep an eye on this, because you've got the background knowledge and the skills to pay attention to this. We get a lot of media coverage of divisive decisions, the 5-4 decisions, those that are highly divided. There are a whole lot of cases where the court isn't very divided at all. They're unanimous, or 8-1 or 7-2. Pay attention to those two, because I think popular conceptions of the court emphasize that division more than perhaps they should. So all sorts of different issues. The final thought I will leave you with, where you talked about as people age, maybe they learn more. I want to suggest a caveat to that. A friend of mine's father once told him, some people live and learn, other people just get older. And so that's the problem we face. Some people are going to live and learn and have that wisdom and knowledge you talked about. Some people just know they're older than they used to be, and that's all we get. But I very much enjoyed our discussion today. I thought you did a really good job of wrestling with these issues.
Yes, thanks very much.
Thank you.
And I'd like to thank your
you.
teacher also for preparing you.
Yes.